Hello, and welcome to Money Mystery No More. To die or not to die, that is the question. Yes, bad joke, but in all seriousness, what if your death were to happen? Are you prepared to have your assets handled the way you want them to be? That is the question. Let's talk about the reality of how essential estate planning provides peace of mind. While estate planning is not an overall exciting conversation, it is definitely super important in the big picture of your financial plan, and once done, can definitely provide peace of mind. If you want to really benefit and get the most out of this video, pay attention and take notes because there is a lot of information to help you through essential estate planning by keeping it simple. It's awesome. And remember, hit that subscribe button to keep getting the latest and greatest information. Okay, let's remove the mystery. Whether you have $10 or $10 million, you most likely have assets, which in turn means you have an estate. We all have an estate, and yours is the total of all of your assets and possessions that you value, whether others see economic value or not. It can be your personal heirlooms, photos, furniture, car, collections, or that favorite coffee cup which makes you smile. Whatever it is, that estate may be small, but it is still yours. It might be literally the clothes you are wearing and nothing more. Even if you still have the right to decide what happens to your clothes if by life circumstances you cease to exist. You leave this world, you pass. It's not a matter of if, it's a matter of when, and you may wish those assets are handled and passed along a certain way. That is what estate planning is all about. You get the ultimate say on who gets your assets, what happens with your assets, what happens to you if things for your health or mental capabilities got real bad, and how all those things happen. It's all about how your assets and affairs are to be handled in accordance with your wishes if you are no longer able to or if you are no longer alive. With a little research, you will find that estate planning is most commonly defined as the process of making plans for the management and transfer of your estate after your death, using a will, trust, insurance policies, and/or other devices. Sure, estate planning can be challenging without some guidance on the various aspects typically involved. Let's simplify this a bit and narrow it down to make it manageable. An important step is to do a thorough walkthrough of your home, storage units, and hiding places to get a complete list of everything you own. This is your estate's assets, which may include money, cash and coins, vehicles, bikes, cars, and even boats, clothing, all of it, whether someone would buy it or not, jewelry, property, includes your home or homes and any land, portfolio, to include all investments, savings, HSA, IRA, 401k, and so forth. The list may go on, but hopefully this helps illustrate various assets to be included in your estate list. After you complete that asset list, you start the planning. Begin this process by defining your goals with what you want to happen with your assets and your personal well-being in the future. This means being real about the current situation and putting it all down so it's clear. This planning will cover asset transfer, which is basically you legally directing your assets to specific entities or people in a lawfully binding manner. While this sounds simple, it covers a wide array of things. Think about all those assets we just talked about in the first step. What if you want your favorite charity to get a gift from you? What if you have a niece or nephew that is struggling in life and you want to give them a little hand up? What about your family, your loved ones, kids, or spouse? Asset transfer covers all this and makes it legally binding. You will have to deal with wills, living wills, trust, lawyers if you want, and maybe you've heard of this, a POA, a power of attorney. Depending on your own situation, you may utilize one, some, all, or none of these different estate planning documents to get your house in order. Planning them gets into medical needs for yourself if you become unable to attend to yourself. If you need someone, God forbid, to make serious healthcare decisions on your behalf, you need that person set up so you don't become a ward of the state or just have some person barking orders out that are against your fundamental beliefs. Planning also involves financial decisions. If you become unable to handle your financial affairs on a daily basis, your estate planning can dictate how the bills get paid, how the bank accounts are allowed to be used, how your minor child is cared for, and more. You see what's happening, right? Your estate planning is your legacy, if you wish. It provides the path for the authorities and those bound to handle your wishes the way you planned. It can seem overwhelming for sure, but you just push forward and do it because it's important to you and ultimately will provide peace of mind. Let's put some substance into the asset transfer just talked about. Understand that your plans become reality in the normal world by implementing a will. It's just a legal document that dictates who gets what when you die. Someone is appointed by you to direct your assets to the people or entities you previously choose. Funny enough, that person chosen is called an executor, but they are also a legal representative acting on your behalf. Wills are required to go through probate, so that's a catch. The court is involved and allows your executor to distribute your assets the way you designated in your will. Note, assets owned jointly with the spouse or others are handled outside of a will. The will also dictates who you want your minor children or dependents to have appointed as guardians. This process with the will and courts is called probate. It is a public process and takes time, but it is not too much of a burden on the executor if the will was properly prepared. So, make sure it's done properly or it will be a money drainer, a time drainer, and a headache for those involved. The probate process will not add much relief to an already stressful situation with your passing. Trusts are a different instrument. Because many people don't want to deal with the probate's frustrating and time-consuming process, they utilize an asset transfer known as a trust. Think of a trust like a safe or a lockbox to hold your assets. Only the designated trustee has access to that safe. All assets contained within that safe are distributed to your desired entities or beneficiaries as you dictate through the provisions established in either a revocable living trust or an irrevocable living trust. With a revocable living trust, your assets are moved outside of probate. At the time of creation, you, the grantor, maintain control of your assets while you are living. A successor trustee will take over once you die. During your control, though, you can be a trustee and move assets into the trust and even make whatever changes you desire with respect to the assets and beneficiaries. Once assets are moved into the trust does become the legal owner. With an irrevocable living trust, your assets are moved outside of probate, but any changes are exceptionally difficult due to required approval from a court and even beneficiaries. You basically lose all control of your assets, even while you are living. Once you die, the trust is handled methodically. People may opt for this type of trust to protect a special needs beneficiary or dependent. They may also utilize an irrevocable trust to avoid or reduce estate taxes. Assets owned jointly with the spouse or others are not covered by a will. This would include retirement accounts, life insurance policies, and even annuities. You are probably more familiar with an asset transfer known as a beneficiary. If you have any type of retirement account, you are required to designate a beneficiary, or more than one in some cases, for plans like an IRA, a 401k, or even a pension. But beneficiary designations also may apply to other things like life insurance, stock instruments, and even HSA accounts. Monies from these types of assets are passed from the financial institution directly to your named beneficiary and may not go through probate. Are you realizing that your beneficiaries should be current? Always remember to keep your desired beneficiaries updated. Life situations can change, and so can your initial designated beneficiaries. If you have a spouse listed on all your financial accounts but end up divorcing, then remarrying, you might want to update your beneficiary, right? While this seems silly, it happens because people forget to update beneficiaries. Gifts or gifting are another common option. If you gift during your lifetime, it does reduce your estate, but there are some tax advantages to the recipient that may be worth looking into. It goes without saying, you really need to dot some I's and cross some T's when it comes to estate planning. Because the legal requirements may differ in your particular state, it might be wise to consult professional help. But an important item is documenting how assets and accounts are titled for ownership purposes. Consider a house. If the home title is in both couples' names, the house is jointly owned even if the mortgage is only in one person's name. In such a case, the house would go to the surviving spouse, as will the debt owed if the mortgage is jointly titled. Life insurance is another item to factor because the money distribution can help your designated beneficiaries in ways you may not have thought about. The distribution of funds may be planned to offset taxes or costs involving assets which will be sold, especially if the sale is difficult, time-consuming, or results in an undervalued outcome. Medical needs are another critical consideration because you may need care while still living. Factoring for and planning for the cost of such care during your lifetime should be prioritized. Maybe you have heard of POAs, power of attorney, and even healthcare directives. These are tools designed to make sure you have trusted people with legal authority to make important healthcare decisions in the event you become incapable or even incapacitated. They might even make financial decisions on your behalf. People acting as a POA have various authorities and discretion depending on how you establish it. But they could even make end-of-life decisions involving your ongoing care if they have a medical POA. Or maybe using a living will might work better for you if you'd prefer the broad powers of a POA to be restricted. Utilizing a living will may only allow someone the decision-making authority on your behalf when it involves end of life, life support, or resuscitation scenarios. Regardless of your choice, having all this worked out ahead of time saves everyone from some pretty heavy stress. And because each state may have variations involving these options, seeking professional help can assist with the ins and outs of your particular estate planning. An estate can be little or quite large, depending on your particular situation. Likewise, you can spend a wide range of money for helpful services and legal input. From flying solo to figure it all out, or using an online service, or going big for expert legal help, you can spend a couple hundred or several thousands. Whatever path you take, it should be clear when done right. Essential estate planning provides peace of mind by keeping it simple. Remember, hit that subscribe button and turn on notifications so you keep getting the latest and greatest information from Money Mystery No More. I'll see you in the next video.